Pursuant to notice, I call up H.R. 7737, the One Agency Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 7737.
Without objection, the bill will be considered as read and open for amendment at any time. The chair now recognizes the gentleman from Virginia, Mr. Klein, for an opening statement.
Thank you, Mr. Chairman. The One Agency Act, H.R. 7737, is a long overdue piece of legislation. Federal antitrust enforcement is currently divided between the Department of Justice and the Federal Trade Commission. This bill will consolidate federal antitrust enforcement in the DOJ's antitrust division, which will be more efficient and productive than the current situation. The bill achieves those benefits by moving antitrust personnel from the FTC to the DOJ. The FTC will be left as an independent commission focused on its consumer protection mission, which will have the added benefit of strengthening enforcement of the consumer protection laws. Unfortunately, many problems exist from having two separate agencies. Expert antitrust lawyers and economists working for the federal government are split between the two agencies. The two agencies then divide up work based on historical precedent or backroom deals. This process creates inefficiencies because industry expertise is split. Consequently, civil servants cannot fully collaborate with their counterparts when doing the same work at a different agency. This inefficiency comes at the taxpayer's expense. For example, through reports, we know the FTC and the DOJ divided up big tech at a secret meeting in Cartagena, Colombia in May of 2019. That means teams of FTC and DOJ lawyers and economists cannot fully collaborate on the issues that affect these digital markets. Another example is healthcare. The FTC enforces the antitrust laws in hospital and pharmaceutical industries, while the DOJ investigates health insurance. If all the expertise was at the DOJ, then these experts could work together with a full understanding of the healthcare sector. Through this committee's work, we also know that, unfortunately for the American people, mismanagement and internal strife define the Biden FTC. Contemporaneous documents written by career civil servants and obtained by the committee have allowed the committee to learn about disarray and an abusive environment at the FTC. Career employees complained that they could not adequately enforce the antitrust laws. The situation was so concerning that one manager thought FTC leadership was trying to lose cases on purpose. The FTC is also fighting constitutional challenges to its authority. These challenges will take years to go through litigation and appeals, but Congress can protect federal antitrust authority now by shifting resources to the DOJ. The DOJ is the better place to locate enforcement because the FTC, in addition to its constitutional concerns, has statutory weaknesses. For example, the FTC has only limited authority over common carriers, insurance, and banking, and only the DOJ can bring criminal antitrust cases under the Sherman Act. So companies being investigated by the FTC have an added layer of protection from criminal enforcement. The Assistant Attorney General for Antitrust is also politically accountable. The President can fire him readily if needed, unlike Chair Khan or other FTC commissioners. It's important to note that the One Agency Act is written to carefully transition personnel from the FTC to the DOJ without disrupting ongoing enforcement. There is not a single ongoing investigation, litigation, or consent decree that will be harmed by this bill. The One Agency Act strengthens antitrust enforcement by putting resources into one agency. It deserves bipartisan support. No one should oppose strong antitrust enforcement, and I therefore urge support for the bill, and I yield back.
Gentleman yields back. The chair now recognizes the ranking member, Mr. Natter, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I strongly oppose this Republican attempt to abolish the police, the antitrust police. Under President Biden, both of our antitrust enforcers have seen historic success. The Department of Justice successfully blocked anti-competitive mergers in the book publishing and airline industries. It is litigating not one, but two historic monopolization lawsuits against Google, and it obtained more than $500 million in criminal penalties against pharmaceutical companies for price fixing. The Federal Trade Commission has also racked up an impressive series of wins. It led the first successful government challenge to a vertical merger in more than 40 years. It is litigating its own monopolization lawsuits against Facebook and Amazon. It secured a lifetime ban from the pharmaceutical industry against the notorious pharma bro Martin Shkreli over his outrageous scheme to hike the price of a life-saving drug. And it has developed a rule to ban non-compete clauses that restrict the freedom of workers to change jobs when they want. These wins are good news for the American people. They should be good news for everyone. Sadly, these victories have been received poorly by extreme MAGA Republicans and their relentless campaign to delegitimize our government. By stripping away the FTC's antitrust enforcement authority, The One Agency Act represents just another front in the majority's war against FTC Chair Lena Khan and her aggressive approach to enforcement. It also serves as a preview of Project 2025, Donald Trump's plan to radically reshape our government if he wins the presidency again. Trump and the extreme MAGA Republicans in Congress have openly admitted that they want to replace the leadership of independent, expert-driven agencies like the FTC with Trump's far-right cronies, just as this bill would allow them to do. Republicans claim that this legislation merely consolidates antitrust enforcement in a single agency and does not substantively limit the authority of the regulators. Not so. The FTC has sole authority to enforce Section 5 of the FTC Act, which prohibits, quote, unfair methods of competition. This language has always been understood to reach more broadly than the Sherman and Clayton Acts, which DOJ enforces. By stripping FTC of its authority to enforce Section 5, without reassigning it to DOJ, the bill effectively repeals this important and long-standing provision of our antitrust laws. Additionally, by giving the DOJ sole enforcement authority, the bill ends the FTC's antitrust enforcement in its own administrative tribunal. This furthers long-held Republican goals of undermining our regulatory agencies. But it completely frustrates Congress' goal in creating the FTC, which was to have an expert body develop antitrust law on a case-by-case basis through its own experience. Finally, this bill provides an unrealistic short time frame for these two century-old agencies to combine their operations, which would lead to chaos and likely disrupt the important cases the agencies are currently litigating against Facebook, Google, the Kroger-Albertsons merger, and many more. It should hardly come as a surprise that this bill would increase the government dysfunction. For extreme MAGA Republicans, the dysfunction is the point. Mr. Chairman, those of us who care about antitrust law recognize a bad merger when we see one. Taking away the unique power that the FTC has wielded for over a century to protect competition may be good for big tech. It may be good for large corporations. And it may be good for Donald Trump and his dark vision for the future of our country. But it would be bad for American consumers. It would be bad for American workers. It would be bad for small businesses. It would be bad for everyone else who benefits from a free and competitive markets. I urge my colleagues to join me in opposing this bill, and I yield back the balance of my time.
The gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Virginia for the purpose of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. The chair recognizes the gentleman from Virginia to explain the amendment.
Thank you, Mr. Chairman. This amendment simply removes the bill's finding section. The change removes a section of the bill that is simply an introduction and does not add any substance to the law. It's not intended in any way to alter the important purpose of the bill. Urge support for the amendment, and I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from California is recognized.
Thank you, Mr. Chairman. I don't always agree with the FTC, so I've been looking at the One Agency Act with great interest. DOJ and the FTC are both independent, yet both work to keep our economy fair and competitive. And that is exactly what Congress intended. Congress created two separate agencies for a reason, because their work is complementary and additive. And by the way, that's good for American consumers, good for Main Street, and for those looking for a level playing field to compete on. And while both FTC and DOJ have authority under the Clayton Act and Sherman Act, Congress specifically gave the FTC an independent authority under the FTC Act. The One Agency Act would undo this and undermine FTC's critical antitrust enforcement abilities. Supporters of this legislation, that is the One Agency Act, claim that it would be more efficient to have one antitrust enforcer, not two. But that argument ignores the fact that FTC has a different mission from DOJ. First of all, the FTC is independent and bipartisan. Its commissioners are Republican and Democrats who can only be removed by the president for cause. And that means that FTC, like other independent agencies, makes decisions focused on what's best for the American people. Secondly, as I mentioned before, the FTC enforces additional laws compared to the DOJ. Section 5 of the FTC lets the Commission prevent unfair methods of competition. That covers a broader set of conduct not covered by other antitrust statutes. And Congress did this with intent. Congress wanted to make sure all anti-competitive activities could be stopped. And unfortunately, the one-stop agency would stop FTC's enforcement of this kind of provisions. And of course, doing this without transferring that authority to the DOJ. In essence, the one-stop agency would effectively kill these important tools currently used to stop anti-competitive behavior. And thirdly, unlike the DOJ, the FTC has the power to write rules that provide clear notices to businesses on what they can and cannot do. And the rules are an important tool to deal with unfair deception in competition and unfair methods of competition. And one good example is recent rulemaking, the FTC proposal to ban non-compete clauses in employment contracts, essentially protecting the freedom of workers to change their jobs. This co-jurisdiction arrangement is not unique to the FTC and the DOJ. For example, both USDA and FDA regulate food safety in a complementary and collaborative manner to serve and benefit the American public. Mr. Chairman, I don't always agree with every decision the FTC makes or every case they pursue, but this legislation is not the answer. The FTC plays a critical role in protecting competition and complements the DOJ. The benefits of the FTC would be lost under this legislation. The result would be possible harm to Americans and small businesses and consumers. Finally, this bill attempts to merge the two agencies without giving them the necessary time, resource, or guidance that they need to combine successfully. That is why I urge my colleagues today to join me in opposing this legislation. Thank you, Mr. Chairman, and I yield.
Gentleman yields back. Who seeks recognition?
Mr. Chairman. What?
Gentlelady from Washington.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report. Gentleman from Virginia reserves a point of order.
Amendment to the amendment.
Without
and the
objection, the amendment will be considered as read. Gentlelady is recognized to explain the amendment.
Thank you, Mr. Chairman. My amendment would not solve every issue with this legislation, but it would permit the Federal Trade Commission to complete ongoing work without interference, allowing this very critical agency to protect consumers, workers, and small businesses in service of the American people. Let me be clear, I firmly oppose the underlying bill, which would weaken antitrust enforcement and undercut the critical work of the FTC. The FTC, for more than 100 years, has worked diligently to protect the American people from anti-competitive, deceptive, or unfair business practices. This is work that ensures that our economy benefits the American people, not just the wealthy corporations and a handful of billionaires. Under the Biden administration and Chair Lina Khan, the FTC has moved faster and further than ever before to help the American people. For example, right now, the FTC is battling big tech in court, opposing grocery store mergers that could lead to store closures and higher retail prices across the country, and examining unlawful mergers in the gas station industry. Through these and other actions, the FTC's work has immediate and wide-ranging positive effects for the American people, increasing competition, lowering prices, and encouraging innovation. To be clear, the work of the Department of Justice's Antitrust Division is also critical for the American people. Under Assistant Attorney General Jonathan Cantor, DOJ Antitrust has successfully blocked harmful mergers and anti-competitive arrangements in the airline and publishing industries and is litigating suits against big tech that will help promote competition and innovation. Both agencies have a role to play, and both have notched tangible wins for consumers, workers, and small businesses, regular Americans across the country who deserve the protection of these agencies. Unfortunately, this bill would allow a future Attorney General to hinder critical ongoing actions by the FTC. My amendment would remedy the problem by allowing FTC to finish ongoing work without the approval of the Attorney General to protect competition on behalf of American consumers, workers, and small businesses. For example, my amendment would protect ongoing FTC rulemaking on non-compete clauses in contracts that I and many other legislators support. It would allow the FTC to effectively litigate its challenge in the Kroger's-Albertsons merger case, supporting good jobs and helping to lower grocery prices for everyday Americans. Without my amendment, these FTC actions and many others would be at risk, threatening the hard-won victories that the Biden administration has achieved for consumers, workers, and small businesses. My amendment would make a very bad bill a little better. But even if my amendment passed and current FTC actions continued unimpeded, the bill would still threaten the critical work of the Commission. Mr. Chairman, we should be proposing and debating legislation to strengthen rather than weaken antitrust enforcement by our government. We should be promoting competition and innovation and protecting consumers, workers, and small businesses, regular Americans across the country who desperately need the government's help to make sure that their interests are protected. Instead, we are debating legislation to hinder rather than promote competition and innovation. I also want to point out that this isn't a battle between Republicans and Democrats. We've actually had some really important bipartisan agreement on some of the work of the FTC and on antitrust in general. It's a battle pitting those of us who fight for consumers and workers and small businesses against the power of mega corporations and their well-heeled lobbyists. There is bipartisan agreement among those of us fighting for the American people that the FTC has won historic victories for consumers and small businesses, and that the work of the FTC should be supported. Mr. Gates, for example, recently went on record about the FTC and Chair Khan saying, quote, "Her work against some of the consolidated market power that hurts consumers has really inspired me." Senator Mike Braun, Republican senator, said that Chair Khan is, quote, "willing to take on some of those industries that look like nobody can take them on and make them more competitive." And Senator J.D. Vance said that Chair Khan and the FTC, quote, "are doing a good job." It seems to me that I'm becoming the bipartisan member of this committee that's quoting Republicans, Mr. Chairman. We'd love to have you on the record as well. These comments underscore the bipartisan popularity of robust antitrust enforcement, and this bill would undermine that work. I'm proud to support the FTC's work to do work on behalf of American consumers, workers, and small businesses, and I oppose any effort to undermine the FTC's enforcement of our antitrust laws. Now is not the time to weaken the work of this critical agencies. I urge my colleagues to vote yes on my amendment and no on this bill. And I yield back.
Gentleman yields back. The gentleman from Virginia is recognized.
Thank you, Mr. Chairman. I oppose this amendment respectfully. The bill as drafted, and in particular page 16, line 8, allows for all ongoing investigations and litigations to continue, as the gentlelady said she would like to see. It also protects all FTC consent decrees that exist, as the gentlelady said she'd like to see. And it provides a mechanism for continued enforcement through both a long transition period and the ability for the FTC to deputize DOJ antitrust lawyers as needed. The bill even allows these deputized employees to use the FTC's administrative process as needed. For future cases, the DOJ will have all the resources and expertise of the FTC, so future enforcement will not be negatively affected. I urge my colleagues to oppose the amendment and I yield back.
The gentleman yield back? Yield?
I yield to the chairman.
I think the gentleman, I'm just going to point out that the one thing Chair Khan is doing is going after one particular business, and she even asked that business, who are the journalists you're talking to? And I think a direct attack on the First Amendment, divulge who you're giving information to, for goodness sake. And as the gentleman pointed out, that business is under a consent decree and will stay that way under this legislation, or stay with the FTC. We have a vote on the floor. So we will recess, just one vote, come back right after that vote, continue to deal with this amendment, and I think that the minority has a couple others, and then we'll move through this bill, but I don't think it'll take us quite as long as some of the other legislation did earlier in the week. So the committee will stand in recess. All right. Committee will come to order. Pending matters, the amendment from the gentlelady from Washington. Who seeks recognition? Gentlelady from North Carolina.
Thank you, Mr. Chairman. I want to yield my time to the gentlelady from Washington.
Gentlelady from Washington.
Thank you so much. I wanted to respond to my colleague, the sponsor of the bill, the gentleman from Virginia, and say if it is your intent that those things that are in my amendment be covered, then I think we should accept the amendment. Let me tell you why. Section 4C of the bill, which you refer to, does include a blanket statement that DOJ will not interfere with current litigation and appeals, but it contains no similar provision for investigations or consent decrees that are governing anti-competitive behavior. And in fact, in section 3A4B, page 6, line 8, specifically permits the Attorney General to continue or dismiss ongoing investigations and consent decrees at his discretion. And so that is one problem. And more importantly, the blanket statement in 4 is fundamentally at odds with the nature of investigations and enforcement actions, which often require additional iterative authority to be successful. Investigations sometimes require additional subpoenas, depositions, or other actions. Litigation may require permission to settle or file particular motions or make other critical decisions. And consent decrees may require enforcement or modification. Section 5 of this bill would force the FTC to ask the Attorney General for permission to take any of those critical actions, and the AG could, at his discretion, refuse to grant permission. So once again, we're putting these critical ongoing investigations and enforcement actions related to those ongoing investigations, taking it away from the FTC and putting it in the hands of the Attorney General. So I think there's conflicting information in this bill, and if the gentleman is willing to work with me, I would at least like to clarify that ongoing investigations and the enforcement actions that may be taken related to ongoing investigations, as well as consent decrees, that are all covered. And right now, the bill does not say that. I yield back to the gentlelady from North Carolina.
And I'll yield to the gentleman if he had a question.
Sure, I know. I thank the gentlelady, and to respond, I think that it does allow for the continued enforcement through the long transition period, but does, as the gentlelady indicates, allow for the DOJ to make a lot of those final decisions about whether resolution of those investigations, whether they're to be continued or to be dismissed. But that's partially the goal of the bill. So the gentlelady's amendment would ultimately undermine the purpose of the bill to transfer that wholly to the DOJ. But the DOJ will continue to have all the resources and expertise of the FTC. It doesn't impact enforcement in any way. You just have to rely on the DOJ to act as the enforcer. And I understand
Ms. Ross,
your
I would
concern
love
about
to have
that.
more time.
So I yield back.
And I'll yield to the gentlelady from Washington. Love playing traffic cop here.
Thank you. So I just wanted to be clear, when you said, in opposing my amendment, you said it already exists, we don't need the amendment. I just want to be clear that the bill is extremely clear that it does take authority away from the FTC, including on ongoing investigations. So all my amendment does is say at least let the FTC proceed with ongoing investigations and any enforcement actions that are necessary on those ongoing investigations, as well as consent decrees, other things that clearly would impede the FTC's current work. It doesn't answer everything in the bill for me, as you know, but it would be an improvement to not interfere with the critical work of the FTC in defending many of the cases that they brought that are about ordinary Americans across the country who are facing high grocery prices, who are facing anti-competitive behavior, and the FTC is doing a really good job, frankly, unlike a lot of FTCs in the past that never used its enforcement authority, it is actually doing that. So once again, I hope members will support the amendment to make this bill just a little bit better, and I yield back.
And I yield my final 10 seconds to the gentleman, and then
I'd be happy to work with the gentlelady. I oppose the amendment as written, but deciding when to cut off that oversight and enforcement of the FTC, depending on the ongoing investigations, I'd be willing to have that conversation.
I yield back.
Gentlelady yields back. Chair recognizes the ranking member.
Thank you. I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I'd like to respond to something that the chairman said before we brought for votes. The chair referenced the FTC's questions to X, formerly known as Twitter, regarding the release of private user data to reporters in violation of the consent decree the company is in with the FTC. The chair stated wrongly that these questions violate the First Amendment. Let's get the history here correct. Twitter has been under a consent decree with the FTC since 2011 to resolve charges that the company deceived consumers and put their privacy at risk by failing to safeguard their personal information. 9 years later, in 2020, the FTC under President Trump opened an investigation into Twitter for violating this consent decree about the company's security of personal information. This investigation resulted in Twitter entering into another consent decree and paying the FTC $150 million for deceptively using account security data for targeted advertising. So when the FTC asked Twitter about their contacts with reporters, it was to ascertain whether the company was yet again in violation of their consent decree by failing to protect the privacy and security of users' personal information, not a violation of the First Amendment. Rather, the FTC was working to ensure consumers' privacy in accordance with their consumer protection mandate under the FTC Act, something that is not affected by this bill, as it focuses solely on ensuring that there will be one less antitrust cop on the beat. I yield back.
I would just point out to the ranking member that in this specific request from the FTC, and I don't have it in front of me, but I remember they named four journalists by name, including Mr. Taibbi and Mr. Schellenberger, individuals who were responsible for breaking the news to the whole world about the Twitter files and the censorship that was going on at Twitter at the behest of the federal government, of the Biden administration. And then they asked the question, are there any other journalists you're talking to? So you can say that's not an attack on the First Amendment, but it sure sounds like it is to me. When you're naming specific journalists in a letter to Twitter and then asking if they're talking to any other journalists, that I think would probably have a chilling effect on freedom of the press. And that's why I made the point that I did earlier, but we appreciate the ranking member's response. Who seeks recognition? Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I want to say that I view this as a very serious piece of legislation because of the potential impact it could have. This is two agencies that have been functioning in coordination for a century now and handling major pieces of litigation and oversight. The ranking member mentioned a couple. I think there's ongoing cases with respect to Google and others right now. There's, I don't know, 8, 9, 10 pending major mergers right now in the United States. I don't know that the antitrust subcommittee has looked at any of them. I'm on the subcommittee. If we've looked at them, I must have missed that hearing. But I did want to ask specifically about this, because merging these two entities in this way, or the authority of these two entities with respect to antitrust, is a very significant step. And so I wanted to ask, I don't recall if there were any hearings that dealt with this, either at the antitrust subcommittee level or the full committee level, but I'll inquire of Mr. Klein if there were hearings that were held that addressed this issue.
If the gentleman would yield, I would answer him by saying that the antitrust subcommittee has, in its oversight of the FTC, exposed many issues with the operations and with Chairman Khan's leadership, or lack thereof, and I would purport that this would be in line with addressing many of those problems that were raised.
Well, let me reclaim my time quickly on that point, because I was here for the Khan hearing. I don't recall any questions being asked with respect to taking the antitrust authority away from the FTC and moving it to the Department of Justice. Certainly not at the logistics of that. For example, how many employees would be impacted with respect to the FTC or the Department of Justice? How many lawyers would have to be transferred from one agency to the other? How many support staff would be impacted by this move? What would be the fiscal impact of that? Because I can recall when the Homeland Security Department was created, I think they spent 2 years working on the legislation to put that together. And it's bigger than transferring the antitrust entity. I'll grant you that, but there was a massive undertaking to take a look at. For example, they had GAO do studies to take a look at what parts should be moved from different departments to Homeland Security and which ones made sense. I note that this bill, speaks to moving authority with respect to certain provisions of the antitrust laws, but I don't know what the analysis is that justifies which provisions would move and which ones wouldn't. And I don't recall us discussing any of that at a full committee or subcommittee hearing either. While I've been here anyway. Chair Khan testified here, I mentioned a minute ago. I don't believe this piece of legislation or anything remotely related to it was raised with respect to her testimony. She wasn't given a chance to respond to it. The head of the DOJ Antitrust Division was here and testified. I don't recall this kind of legislation being raised with him or any questions asked with him about the wisdom of doing this. I don't recall seeing any kind of GAO study in support of this effort, or even whether there's a need for this effort. And let's say, just assume arguendo that it might make sense to do it, how to do it and how long it might take to do it, that hasn't been addressed either. I know there's 180 days here for putting the merger together. That sounds pretty optimistic to me. Even if this were to happen, having a sense of how the Department of Justice works and the federal government works, it's hard to do much of anything in 180 days. And I don't think there's been any kind of correspondence with respect to the FTC or the Department of Justice that raised this legislation and sought their comments on it. And even if your view is that the Biden administration would just oppose this out of hand, I would note that there are a number of heads of the FTC and the Department of Justice Antitrust Division who worked in Republican administrations. In fact, I worked under one early in my career, a guy named Jim Weiss, who was an outstanding antitrust litigator. Why don't we try and hear from them as to whether they think this would be a wise move or not? So I appreciate the members' legislation here, but I think I don't mean to be harsh, but not ready for prime time. And I don't think we should take a move this big and this important with the absence of a record like we've got before us today. And with that, I yield back.
Gentleman yields back. Gentlelady from Wyoming, recognized.
The current dual structure of authority that is split between the FTC and DOJ antitrust results in delays in enforcement, divides expertise, and creates uncertainty for the regulated parties. Delays can often occur as the FTC and DOJ determine who has jurisdiction, and it's not clear-cut because they split issues within larger policy fields, notably healthcare and big tech. This means that the regulated entities can never be certain which agency they can fall under. Only the DOJ has the power to bring criminal antitrust actions, which means that the FTC has to rely on criminal referrals anyway. The FTC structure is rife with abuse and very inefficient. The FTC's existence is on shaky constitutional grounds. It promulgates regulations with the force and effect of law, then investigates violations of its so-called law, and brings enforcement actions, and then hears complaints before its own ALJs and commissioners. Obviously, the deck being stacked against the regulated parties. The FTC is a leading agency in terms of denial of rights through the administrative law court system. Even worse, the FTC, the commission itself If there is a decision in favor of the regulated party, the commission itself frequently reverses any ALJ determination. The allegations that Khan has instructed the ALJ not to issue decisions anymore, I think speaks loudly, and this comes with the scrutiny of Khan's success rate. Chair Khan was appointed by Biden without Senate notification or approval. The shortcomings in the FTC structure can be exacerbated by bad leadership, as seen under Chair Khan. Career staff and managers concerned with her management style have been legion. Her agency, the FTC, went from being one of the agencies where people enjoyed working and had one of the highest in terms of employment satisfaction to one of the lowest under her leadership. Managers warn of outside influences on her decision-making, her pursuit of losing cases, which affects the rest of the enforcement agenda. In fact, I believe she's lost almost every single case that she's brought because she's not bringing them pursuant to what the law is. She's bringing them pursuant to what she wants the law to be. Staff are cut off from Khan with little communication, which harms the litigators and investigators who have the skills to win cases, and she keeps staff in the dark about goals and direction. Khan's Federal Employee Viewpoint Survey results show how bad things have gotten inside the FTC. The 2022 numbers are really bad. Khan argued too early into her tenure to paint a complete picture. She just failed to do it. And in response, here are the 2023 results. Honesty and integrity are down 29% from 2020. Respect for senior leadership is down 30% from 2020. And motivation and commitment are down 34% since 2020. I think if there's anything that this body should do, it is to try to reclaim our legislative authority from administrative and regulatory agencies. To the extent that we can combine and consolidate agencies and streamline regulatory agencies, I think that it would be a good thing for us to do that. I think it's our responsibility to do that. I think that this is the beginning. This is the first of what I hope are many, many bills, finding ways to consolidate agencies or abolish agencies entirely that we don't need. I support this bill. I support Mr. Klein's efforts, and I urge adoption and passage. With that, I yield back.
Gentlelady yields back. Question occurs on the amendment from the gentlelady from Washington. All those in favor say aye.
Aye.
I'm so sorry. Gentlelady from Vermont wants to speak on this great amendment from her colleague.
I thought maybe you were mistaking me for the gentle lady from Washington.
Not at all. I know Vermont from Washington.
Thank you, Mr. Chair. There simply is no evidence that dual enforcement of the antitrust laws has wasted federal resources or weakened antitrust enforcement. To the contrary, under President Biden, the DOJ and the FTC have each achieved historic successes, blocking anti-competitive mergers, bringing historic monopolization cases, and writing new rules to promote fair competition. It's really important for us to remember that the FTC enforces a statute that DOJ does not, the Federal Trade Commission Act, whose coverage is broader than that of the antitrust laws enforced by DOJ. And although the bill purports to transfer all FTC antitrust authority to the DOJ, it is actually silent on Section 5 of the FTC Act, which prohibits unfair methods of competition and thus effectively repeals one of the country's oldest and most flexible antitrust laws. In addition, in areas of antitrust enforcement where the agency's authority overlaps, DOJ and the FTC have developed an interagency clearance process to avoid duplicating work. A GAO report from last year found that conflicts between the agencies over the clearance process are actually rare. So this is not needed. We do not have evidence that this is, in fact, the direction we should be going in, and I yield back.
Gentlelady yields back. The question now occurs on the amendment from the gentlelady from Washington. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
Roll call, please.
Ranking member requesting the roll call. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? No. Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Issa, you're not recorded. Mr. Issa votes no.
Clerk will report.
Mr. Chairman, there are 6 ayes and 10 noes.
The amendment is not agreed on. Who seeks recognition? Ranking members recognized.
I have an amendment at the desk.
Clerk will report. Mr. Klein reserves a point of order.
Amendment to the amendment and the nature
Without
of it.
objection, the amendment be considered as read. The gentleman is recognized, the gentleman from New York is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, my amendment would clarify that the Federal Trade Commission would retain its power to create rules and enforce them under Section 5 of the FTC Act after its antitrust authorities are transferred to the DOJ. Section 5 of the FTC Act gives the Commission the authority to act to, quote, prevent unfair methods of competition and unfair or deceptive acts or practices in or affecting commerce, close quote. Under Section 6G, the Commission also has the power to create rules to protect against these harmful practices. The bill as written would prohibit the FTC from creating these rules as it prevents any agency from using the Section 5 authority. Just last year, the FTC announced a proposed rule barring non-compete agreements in employment contracts. Non-compete clauses impose numerous harms on the market, like depressing wages, lessening wage growth, and decreasing small business formation. Even in states where non-competes are unenforceable, nearly 40% of workers reported turning down a job offer because of a non-compete clause in their contract. The negative effects of these clauses are even more pronounced for women and people of color. Around 20% of workers are subject to non-competes, and roughly 38% have been subject to a non-compete clause at some point in their lives. Clearly, a ban on non-competes would be a win for worker wages, a win for small business creation, and a win for economic growth of our nation writ large. That is why this amendment is essential to ensure that the FTC can continue to issue such important rules under Section 5 and Section 6G of the FTC Act. I ask that my colleagues support the amendment, and I yield back the balance of my time.
Gentleman yields back. Gentleman withdraws his
Point of order.
point of order. The gentleman from Virginia is recognized.
Thank you, Mr. Chairman. I respectfully oppose the amendment. The FTC under this bill will remain a stronger agency, more focused on its consumer protection mission. The consumer protection powers of the FTC include consumer protection rulemaking under Section 18 of the FTC Act. Congress specifically gave the FTC this power in the Magnuson-Moss Act. The FTC does not have the statutory power to make substantive competition rules, and the current attempt at the FTC to make a competition rule is likely unconstitutional under the non-delegation and major questions doctrines. Regardless of the legality of competition rulemaking, the bill would not stop ongoing rulemaking at the FTC. The carefully crafted process for shifting resources from the FTC to DOJ under this bill allows ongoing actions to continue. I urge my colleagues to oppose the amendment and yield back.
Gentleman yields back. Gentleman from Maryland is recognized.
I yield to the gentleman from New York.
I thank the gentleman from yielding. I want to reply to Mr. Klein. It is true this bill would not stop ongoing rulemaking. It would, however, prevent future rulemaking. The authority that the FTC gives, the authority that Section 5 of the FTC Act gives the Commission to, quote, prevent unfair methods of competition and unfair or deceptive acts or practices in or affecting commerce, and the authority given to the Commission to create rules to protect against these harmful practices under Section 6G would be stripped from the FTC and not given to the DOJ. So there would be no authority to prevent unfair methods of competition and unfair or deceptive acts or practices affecting commerce. That doesn't make sense. And that's why this amendment is necessary. And although Mr. Klein says it would not stop ongoing rulemaking, it would stop new rules. So in the future, neither the FTC nor the DOJ would have the authority to do any of this, and that would be greatly harmful to workers, to working people, to small businesses, and to the economy at large. I thank the gentleman, and I yield back to him.
I yield back.
Gentleman yields back. Gentleman from North Carolina is recognized.
I'm not sure any amendment could better illustrate the need for the bill. This amendment ought to be defeated, but the argument in support of it. The idea that, and you take non-competes as a good example. Non-competes and whether contracts restricting competition between persons should or should not be lawful objects of contract has been, debated for 100 years or more. And states across the United States have come to differing conclusions about the degree to which you should be able to have restrictions on competition, the degree to which it protects proprietary interests that are legitimate of businesses, that as corporate forms of business expanded, needed to be protected because every corporation is served only through people, and people are going to have contacts with customers. And so in my state, for example, that was the determinations over time by a long process of judge-made law and some statutory law. Other states have done it by statute. But, the notion, first, we've had debates here and bills from the Democrats about banning non-competes. I've voted to ban certain categories of contracts when they would, conceal sexual misconduct and so forth. But I don't oppose, because I've seen their utility in a long career in practicing law, that non-competes are valuable. The notion that some bureaucrat in some agency would suddenly in 2024 or 2023 make a law that bans non-competition agreements when decision-making power is supposed to be distributed among legislatures in the states across the country and the lawmaking power here in Congress, that's an example of how crazy things have become. And they do it predicated on a statute, and I don't remember exactly when the FTC Act was passed. Most states have little FTC Acts, but I think it's a New Deal era statute that merely prohibits unfair competition and unfair and deceptive methods of competition, and because Lena Khan is, a loud and proud, pro-regulation person, she's coming out, almost 100 years into the experience under that statute and discovering that it prohibited non-competes all along. That's insane. That is not what should be happening, and I think it's maybe the best argument. I appreciate the ranking member offering the amendment, is if only to galvanize folks who would say, yeah, that's exactly what we ought to be stopping, is the untrammeled, unrestrained power of a handful of bureaucrats or a favored, insurgent bureaucrat who comes out of a congressional committee staff to go over to an agency, take it over, and remake the commercial world. That's insane. That's not what our founding fathers ever envisioned in terms of the making of law. And it is It is one of the key reasons why this country is less and less in the control of its citizens, why the consent of the governed has become an afterthought in this country. And it needs to be fixed.
Would the gentleman yield?
I have a minute 30. Yes, I'll yield to the ranking member.
I thank the gentleman for yielding. I point out, first of all, the FTC comes from 1914 under Woodrow Wilson, not
Well, even earlier. Then we'd have a full 100 years before Lena Khan discovered that, oh yes, it banned these things.
That wasn't the main point of what I wanted to say.
Okay.
I want to say two things.
In fact, you helped me. You augmented my point on that
you
part.
don't like Lena Khan, so you're going to get rid of half the FTC's authority. That doesn't sound right. But two, non-competes make sense for certain key personnel who have information about a business's action, about a business's secrets, and so forth. They do not make sense for restaurant employees.
So I'll reclaim my time. I concede to the ranking member, there are situations, in fact, I opened with that point, that there are certain circumstances in which states have allowed them and certain circumstances in which we haven't. It's an ongoing appropriate decision about your commercial contract law, and it ought to be decided by state legislatures. And Mr. Nadler, you and I can disagree. I'm sure we do. We disagree about much. But the way we resolve that is in a legislative body with votes on proposals, not by empowering some single bureaucrat. And it's not even about Lena Khan, except she's a great example of the person who really wants to embrace and exploit that power with everything she's got. I yield back.
Gentleman yields back. Who seeks recognition? Question occurs on the amendment from the ranking member from New York. The clerk will call. All those in favor say aye.
Aye.
Those opposed, no. No. Opinion of the chairs, the noes have it.
Chair, roll call, please.
Roll call being requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Isa? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran?
That's whatever you want.
Ms. Lee?
Get some more amendments coming.
Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Nagoose? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Moore? Mr. Moore votes no.
Mr. Issa votes no.
Mr. Issa votes no.
Mr. Johnson?
Mr. Johnson votes yes. Mr. Van Drew, you're not recorded. Mr. Van Drew votes no.
Gentleman from Florida.
Mr. Gates votes yes.
Clerk will report. Gentleman from Wisconsin.
Mr. Tiffany? Mr. Tiffany votes no.
Miss, gentlelady from Pennsylvania?
Ms. Dean, you are not recorded. Ms. Dean votes aye.
Clerk will report.
Mr. Chairman, there are 8 ayes and 12 noes.
The amendment is not adopted. Who seeks recognition? Gentleman from Georgia is recognized.
Mr. Chairman, I have an amendment at the desk.
Gentleman has an amendment at the desk. Gentleman from Virginia reserves a point of order. The clerk will report.
Amendment to the amendment and then nature.
Without objection, the amendment will be considered as read. The gentleman from Georgia is recognized to explain his amendment.
Thank you, Mr. Chairman. While the American economy has grown exponentially since the antitrust laws were passed over 100 years ago, the funding from our critical frontline antitrust enforcement agencies, the Federal Trade Commission and the Department of Justice, has failed to keep pace. For example, in 2022, the DOJ's Antitrust Division had 352 fewer employees than it did in 1979, which is the year I graduated from law school 43 years ago. And in recent years, both the DOJ and FTC have seen historic increases in the number of pre-merger filing notifications under the Hart-Scott-Rodino Act. In 2022, for example, the agency saw a 92.5% increase in notified transactions under the HSR Act from 2020, a 92.5% increase. And almost a third of all of these transactions were from the consumer goods and service industries. In line with this increase and with the 2021 competition executive order, agencies have also been tasked with significant increase in enforcement challenges, further straining their limited resources. This bill would cut the number of our frontline antitrust enforcers in half by moving all antitrust enforcement of the Sherman and Clayton Acts to the DOJ, thus eliminating half of the work of the FTC. But the One Agency Act does this without at all accounting for the impact that this bill will have on the DOJ. The DOJ is bringing several historic cases against corporate parties whose size would have begged belief with the antitrust laws that were passed in the early 1900s and even when the Hart-Scott-Rodino Act was passed in 1976. Cases against Google for an alleged monopoly in search and ads, against Apple for anti-competitive actions in the smartphone market, and a soon-to-be announced case against Ticketmaster for an alleged monopoly over the ticketing for live events. Therefore, I respectfully offer my amendment to authorize such funds as necessary to the DOJ to ensure that they have sufficient resources to enforce our antitrust laws. If my colleagues truly want to consolidate the enforcement of the Sherman and Clayton Acts under the DOJ, they should join me in supporting this amendment to ensure that corporations cannot break our antitrust laws without consequence. If you support the intent of this bill, you should support my amendment to ensure that the bill works for the American people and does not just open the door to less law enforcement. And with that, Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Virginia is recognized.
Thank you, Mr. Chairman. I respectfully oppose the amendment. The bill, as the gentleman stated and as he strikes in his amendment, includes transfer of FTC antitrust funding to the DOJ, and in the bill, it does define antitrust funding as all amounts appropriated before the effective date by an act of Congress to the FTC that are designated by Congress or the FTC for an FTC antitrust unit. So that money that is there has been authorized, is transferred, and appropriations will continue to be allocated as needed to the DOJ for the implementation of the antitrust enforcement mechanisms within DOJ as transferred from the FTC. So I believe everything that is necessary for appropriate enforcement is there. For that reason, I oppose the amendment.
Gentleman yields back. Who seeks recognition?
Yeah. Mr. Chairman,
The ranking member is recognized.
I move to strike the last word.
Gentleman is recognized.
I yield to Mr. Johnson. Your mic's not on.
Thank you, Mr. Ranking Member. Mr. Klein makes the argument that the funding will be there for this transfer of antitrust enforcement from the FTC to the DOJ. In other words, assuming that with this change if this change is made, then the funding will be there. But nowhere does this bill or any other bill, to my knowledge, authorize any funding for in support of this change. So what this change is actually doing is to put more on the plate of the DOJ, which lacked adequate funding to begin with to enforce the laws that have become more complicated. And ironically, the FTC does not have enough funding either to do the job that it's been tasked with doing. As I pointed out, a 92% increase in business, but yet the DOJ's antitrust division had 352 fewer employees back in 2022 than it did in 1979, which was 43 years prior. The majority has investigated alleged mismanagement at DOJ and FTC, and their own report noted that both agencies lacked sufficient resources to carry forward successfully their mandate. And so this amendment would just simply put this committee on record as being in favor of whatever funds were necessary to effectuate this change, this transfer of antitrust enforcement from FTC to DOJ. Make sure that DOJ has the sufficient resources to carry forward its new mandate. So I would ask my colleagues to support this amendment. I think Representative Klein has made the case to support this amendment. Nothing wrong with a statement stating that we agreed to appropriate as much or to authorize whatever resources are necessary to effectuate this change. And with that, I yield back.
Let me point out that, as Mr. Johnson said, this goes back to 1979 when the economy was much smaller. And we are not, by this amendment, appropriating funds. We're simply authorizing such funds as are necessary for the Attorney General to carry out the powers that are transferred to him from the FTC. It will still be up to Congress to appropriate the funds, so I don't see how anybody could properly oppose this amendment. If you're transferring a job from one agency to another, you have to authorize the funds to be transferred from one agency to the other. It's not that you're spending more money. The money is now authorized for FTC, so you'd simply switch the authorization to the Department of Justice. And as to the amount, Congress has to appropriate money in the appropriations bills in ensuing fiscal years. So I think that this amendment is well taken, and I oppose the bill. But if we're going to transfer these duties to the Department of Justice, we should transfer authorization for funding also to the Department of Justice so that they can be effectuated. I yield back.
Gentleman yields back.
I yield to the gentleman from Maryland.
Thank you, Mr. Ranking Member. And just along the lines of the point I made earlier, transferring the funds for that follow the position from the FTC to the Department of Justice, that's one expense. But we know it's not going to be free to move all of the FTC employees, their authority, their files, their computers, all of that stuff. You have to pay to move all that. There's an expenditure that comes with that. And you're probably going to need funds to cover, and we know this from experience from when we've combined agencies previously. You might even need consultants to come in and figure out how to do it the right way. We certainly don't want to do this in a way that's damaging to the Department of Justice or to the FTC, I'm sure. That's not the author's intent. So to make sure it's done the right way, you might need consultants to help you figure it out. You're certainly going to need in-government people to help figure it out, whether that's the GAO or GSA or somebody else. The bottom line, though, is it's not free. And Congressman Johnson's amendment would allow expenditure of the funds to cover that. So I think it's necessary if our colleagues are serious about actually conducting this move. And with that, I yield back.
And I'll yield back.
Gentleman yields back, seeks recognition. Question occurs on the amendment from the gentleman from Georgia. All those in favor say aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. And the
Roll call vote, please.
roll call vote being requested, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Nagoose? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant?
Gentleman from North Dakota.
Mr. Armstrong votes no.
Clerk will report.
Mr. Chairman, there are 6 ayes and 14 noes.
The amendment is not agreed to. The gentlelady from Washington is recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report. Point of order reserved by Mr. Klein.
Amendment to the amendment.
Without
and then-
objection, the amendment will be considered as read. The gentlelady from Washington is recognized to explain her amendment.
Thank you, Mr. Chairman. My amendment is about preserving another critical enforcement tool in the arsenal of our antitrust enforcers, the Robinson-Patman Act. The Robinson-Patman Act is one of the most important but lesser-known antitrust laws, and it's probably the FTC's best tool to tackle high food prices and concentration in grocers, supermarkets, food producers, and food wholesalers. Grocery prices are higher than ever, in part due to record levels of grocery store consolidation that is squeezing American families and consumers. We need every tool in the toolbox to keep grocery prices low, and FTC enforcement of the Robinson-Patman Act is one of those tools. The Act gives the FTC the ability to challenge unfair pricing practices that disadvantage small businesses and independent grocers, practices that not only lessen competition, but also raise food prices, which is something that so many Americans are dealing with across the country. The Patman Act prohibits sellers from engaging in price discrimination and prevents sellers and buyers from skirting around the price discrimination ban by giving more favorable commissions, brokerages, processing fees, handling fees, or other similar schemes to those giant retailers and grocery stores, and disadvantaging the smaller grocery stores. Today, the food industry is more consolidated than when Congress adopted the RPA. Currently, 4 food retailers account for over a third of national grocery sales. Grocery suppliers are also highly concentrated. 4 firms controlled more than 60% of sales in most grocery categories in 2019, and some categories are almost entirely controlled by a single food company. Because of this concentration, dominant retailers can extract more favorable prices and terms from suppliers beyond what might be justified by economies of scale. Suppliers are often forced to make up their losses by charging higher prices to independent, smaller grocery stores. Allowing the FTC to enforce this critical law would help lower grocery prices, protect small businesses, and help all American families by lowering grocery prices. I cannot imagine that the Republican majority would not want to lower grocery prices for American families. I hope that we can agree that the FTC should continue to enforce this competition law. Grocery prices are squeezing American families, and we need to protect the FTC's critical Patman Act authority so that they can continue to protect small businesses and families. With that, I yield back.
Gentleman yields back. Gentleman from Virginia is recognized.
Thank you, Mr. Chairman. With respect, I oppose the amendment. We all care about grocery prices. We all care about the enforcement of this law. The DOJ currently has that enforcement authority, and that would continue under this shift, simply moving it or eliminating its existing authority from the FTC, consolidating it in the DOJ where it already exists, simply would continue that long tradition of protecting consumers, but doing so in a more efficient and comprehensive manner from the DOJ. I yield back.
Gentleman yields back. Gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman's recognized.
Ladies and gentlemen, let's not be fooled about what's going on here. A transfer of antitrust enforcement functions from the FTC to the Attorney General, or the DOJ, Department of Justice. Let's say under the leadership of a guy like William Bill Barr, what kind of a Justice Department could we depend on to enforce the antitrust laws under such a regime, especially if you have a history of starving that agency of its manpower and resources to effectively enforce the law? Why would you now want to make a shift from the FTC to the DOJ? What motivates that? Well, the gentleman just said that we, I guess Republicans, care about grocery prices, but unfortunately, not for the same reasons that folks on this side of the aisle care about grocery prices. We care about how much consumers and workers and the little guys have to pay. But my friends on the other side of the aisle are more concerned about high grocery prices that reward themselves and their friends who actually own the businesses that are selling the groceries. That's who they care more about. And so this is some legislation in search of a problem. The problem really is lack of resources to enforce the antitrust laws over the years. That has resulted in consolidation so that a few firms control grocery prices because they are the ones who sell the groceries. So the American people should understand what we're doing here. And it's not to make prices lower for consumers. It's actually laying the groundwork for big business to continue to charge whatever they want to charge. And with that, I will yield to the gentle lady from Washington.
Thank you so much, Mr. Johnson. You know, as you were speaking, it was occurring to me that this is actually the crux of the issue. I actually think the reason that this bill has emerged without a hearing, without any discussion, without any witnesses talking about what would be one of the most significant changes that we've had for two major agencies, as Mr. Ivey had pointed out in his previous comments, it occurred to me that maybe the reason is actually that the FTC is finally being very, very successful. Could that be, Mr. Johnson? I was looking up some examples of where the FTC has been seeing success, and I'm going to see if I can print these articles out and enter them for unanimous consent. But the FTC seeing success after merger setbacks, that was in Law 360. FTC Chair Lina Khan takes victory lap on blocking NVIDIA ARM merger. After a storm of criticism, Lina Khan's FTC has a $7 billion victory related to a cancer test acquisition. We could go down this list. But it occurs to me that the attacks on the chairwoman herself, Lina Khan, and the attacks on the agency are coming precisely because the FTC is doing something that it hasn't done for some period of time, which is that it is actually successfully utilizing the tools that it has in the toolbox to protect American consumers, small businesses, others across the country who desperately need the protection of these government agencies, including the FTC. And certainly on grocery prices, and this amendment is about ensuring that the Patman Act is still able to be utilized by the FTC, I would just say once again that there is really no reason why my Republican colleagues would not want to ensure that the FTC continues to be able to use this critical law unless you didn't want to actually serve American consumers with lower grocery prices. So I thank the gentleman for yielding, and I thank you for your clarity, which gave me a lot of clarity about exactly what we're doing here today with this bill and this hearing.
Thank you, Madam Chair. I yield back.
Gentleman yields back. I would just say, well, then why does eggs and milk cost so much? If the FTC is successful and the Patman Act will lower grocery prices and the FTC has the authority to enforce that act, what the heck are they doing? Because everything costs a whole lot more. And all the gentleman's amendment does, the DOJ can, let's give the DOJ a chance to do it. Maybe they'll do better. I'll yield to the gentleman from Virginia.
I thank the chairman. I would say, in addition to poor or failed enforcement, and if we want to stay here all day, we can go through all of the cases that Lina Khan has had overturned by the courts and essentially been shot down, which far outnumber the number of successes she's had. But we won't do that. But instead, I would like to point out high grocery prices that have occurred in the last, let's say, 3.5 years, coinciding with the beginning of this administration, really caused in large part by the massive appropriations bills, the massive Inflation Reduction Act that was passed by the gentlelady, by the gentleman from Georgia, and helped to inflate grocery prices to levels that have not been seen in decades and are really, truly putting a huge amount of pressure on working families. So if my colleagues really, I'm really glad to hear they're finally coming around to recognizing that Americans are suffering from high grocery prices, because my constituents have been complaining about them for the past 3 years under this administration, and every time they do, the Democrats pass another appropriation bill and make it worse. So with that, I yield back.
Would the chairman yield?
Yeah, I will yield to the ranking member, then to the gentlelady from Washington.
Mr. Chairman,
It's my time.
first of all, let me reply to Mr. Klein. Inflation started with the pandemic. That's what caused the inflation. We're still reacting to that. Inflation in the United States is the lowest inflation rate of any country in the developed world. It is not the Inflation Reduction Act, it's not the policies of the Biden administration that caused high inflation, it's the pandemic. You might say it's the policies of the Biden administration that has caused our inflation in grocery prices and other things to be less than that of any other major country. Now, the Robinson-Patman Act is a very important antitrust law that is currently enforced by both the DOJ and the FTC. But the fact remains that Americans need and deserve strong enforcement of the Robinson-Patman Act, a role that the FTC critically plays. Americans deserve competitive grocery prices, and we should not eliminate another Robinson-Patman Act enforcer under the bill. And the fact is that it's the FTC and the enforcement of the Robinson-Patman Act that is pushing a downward pressure on grocery prices, as opposed to the inflationary pressure that's coming around the world. A 2024 FTC report found that inflation in prices came because of large firms inflating prices. Another reason, a harm that the FTC can enforce against. And in fact, the FTC is bringing cases under the Robinson-Patman Act to stop this illegal conduct. It is essential to reduce the impact of inflation, specifically on grocery prices. I urge my colleagues to support the amendment to ensure Americans are not paying too much for groceries. Well, they're paying too much, but are not paying unnecessarily too much for groceries, and further inflating profits for large grocery companies. I yield back.
Does the gentleman from, I'll be yielding my time. I was going to yield to Washington, and you can get your other, or I'll yield to? Okay. Okay, well, I got to go to them again, too, but I will yield the last minute to the gentlelady from Washington.
Thank you, Mr. Chairman. Mr. Nadler said some of what I wanted to say about inflation and what is causing inflation, and the research that has shown that it is actually these consolidations and the price gouging of the biggest corporations that is leading to the vast majority of inflation in regular consumer goods and groceries. But the other thing I just wanted to say is, the gentleman well knows that these antitrust cases take a long time in court. You well know that they are litigated for years before there are successes. And the reality is that we are finally starting to see some of those successes. So the fact that we haven't already been able to do this is not a sign of the FTC's unwillingness. It is a sign that these things do take time, and essentially deconsolidating huge markets is a tough thing to do. That's why we need an aggressive enforcer at the FTC with the full jurisdiction of the FTC that they've had for 100 years. And I think that's really important. I thank the chairman for yielding. Yield back.
I yield back.
Gentleman from New Jersey, if this side's, the gentleman from New Jersey recognized.
Thank you, Chairman. Let me just say from the outset that I support the underlying bill, but I think we all share the concern, and we're going to come up with different reasons why. But if you talk to real people every day, I do, I'm sure most of the members do, their utilities are going up, their homeowners insurance is going up, their car insurance is going up, their food prices are going up, their taxes are going up. It's rough. If you are a middle-class person or less, and you're working, you are struggling. It's not easy. With that being said, I support the underlying bill and we'll vote for it, but I have a sincere question from the gentlelady from Washington, if she would yield.
Sure.
My question is this: is there anything that leads you to believe that the Robinson-Patman Act would not be enforced, and that we would not be able to enforce it if we made this change? I want to be specific on your bill. I know we're talking a lot of the bigger issues,
I appreciate
that does concern me, and this is a sincere question.
I appreciate the question. What the bill is doing is taking away the enforcement authority and the ability of the FTC to be able to move on the Robinson-Patman Act, and it's actually giving all of that authority to the DOJ and requiring that the DOJ approve all of that.
Does the DOJ not have that authority already?
I think the other issue here is also the resources to the FTC and ensuring that the FTC has the full resources to be able to continue its enforcement.
And that I agree, and that's sort of a separate issue. I'm just addressing literally your amendment, because these prices do concern me. It's, you know, we get to the real thing, we're here, we're comfortable, we're all talking to each other, but there's people really, for real, struggling out there. And I would want to be sure that this Robinson-Patman Act would be enforced and that we would move along, hopefully, and do more than we, quite frankly, are currently doing on this issue.
I really appreciate the gentleman's question, and I think that's the underlying concern I have with the bill, is that it's taking the authority to make decisions about what moves forward, what doesn't, and centralizing it with the Department of Justice. And on the Robinson-Patman Act in particular, the FTC is actually reversing decades of under-enforcement on the Robinson-Patman Act. And they're making big strides to move that forward, but they need us to be able to continue to keep that authority with
I'm
them.
going to yield to you. Okay, I thank the gentlelady from Washington. Chairman, if I may, I would like to yield from the gentleman, the sponsor of the underlying legislation, if he could just specifically answer those questions.
Well, I thank the gentleman, and I want to assure him that enforcement of Robinson-Patman will continue, and in fact, the consolidation will strengthen DOJ enforcement because you will have those resources transferred from the FTC to the DOJ. The gentlelady disagrees, but more resources does not necessarily mean less enforcement. In fact, it could mean more enforcement, more likely would, and that's why we're doing this. So I yield back to the gentleman.
And I yield.
Would you yield?
Yes, to Mr. Issa.
You know, the gentlelady from Washington mentioned a case as a victory, and I just want to go on record saying if she was talking about Lumina Grail versus FTC, she's talking about one of the great miscarriages. Not only did the FTC use the wrong statute to declare it, and yes, Lumina did divest of this emerging technology, but let's understand, this was a technology that once belonged to Lumina. They spun it off in hopes of it being developed. As it became aware that it was going to go to market, the actual partially owned division, Grail, asked to be reacquired so that the funds they needed would be readily available from the larger company for a testing system that doesn't exist. And yet the FTC reached in and said, it's anti-competitive to have a large company buy a small company and very quickly monetize, I'm sure, a successful procedure that otherwise without the money wouldn't have happened. So if she wants to bring up examples, please consider bringing up an example of a success where Americans would have gotten more as a result, rather than Americans not having a life-saving test for years to come as a result of that divestiture. I thank the gentleman for yielding.
And I will yield back in a moment. I just want to say quickly that I think there's a great deal of dysfunction with this FTC and share that concern. My only other concern is I wanted to make sure, and I'm being ensured, that this Robinson-Patman Act will be enforced by the FTC if this actually comes to fruition. DOJ, I'm sorry, the DOJ. I yield back.
Gentleman yields back. Gentleman from Maryland is recognized.
I was really trying to sit this one out, but my colleague from New Jersey, I do want to say this. The antitrust subcommittee, I think, has only met twice, but one of the hearings that we had actually touched on an aspect of this issue. And so Chairman Massey brought in a number of small farm owners who testified about the impacts of, a lot of it was focused on the regulatory aspect, but during the course of their testimony, one of the things that became clear was they all agreed that the big four, as they called it, the agriculture companies that sort of control production, are being unfair to them, and it's causing prices to go up because they have control over what's being developed and grown by the small farmers, and they're not giving them fair compensation and still jacking up the prices, and they're getting more than they should. Now, we kind of left it at that. I was actually, it was Chairman Massey's hearing. I was actually sympathetic to the testimony that was given. It caused concerns for me And I thought that the antitrust subcommittee, this is the kind of thing that we should look at. And I still view that as something we should do. And I would welcome that too, because it might not, but it might address some of the concerns that you just raised and the gentlelady from Washington State. But that brings us to today. This legislation does nothing to address those concerns that were raised. The consolidation of the FTC and the Department of Justice with respect to this antitrust authority, there's no evidence that's been presented. There have been assertions and claims made by the author of the legislation, but there's no factual basis. There's no GAO determination. There's nothing that supports the claim. And I think that this committee ought to do things that are data-driven and evidence-based, especially if it's a big move like this. And to my colleague from New Jersey, Maryland, we're not all that different. We're having the same issues with costs and prices at the grocery stores that you all are. We're both in the Mid-Atlantic region. Our costs aren't that different. I share your concern, and I'd love to see action to try and address that. I know that there are economic forces that are bigger than the legal piece of this, for sure, as the ranking member pointed out. But to the extent the committee has jurisdiction and can have an impact on things like that, those are the kinds of hearings I think we should be doing.
Would the gentleman yield just a moment?
Absolutely.
I thank the gentleman. I share those with you. I mean, and I think republicanism in its truest form is concerned about the working person, the small business, and we are losing something in this country. I think there actually is some agreement on both sides of the aisle of this, and the days of the monopolies, monopoly busting are certainly not here now because they're getting bigger, bolder, stronger, and richer. So I don't disagree with you on that. I don't necessarily agree with you on how good a job the FTC is currently doing. I don't believe they are. And I think that's one of the reasons for this legislation. We need to do better, and I would hope in the Department of Justice we would. And if we don't, I think we need to continue to pursue that in a bipartisan way. I yield back.
I appreciate that, and just before I yield to others, I'll say this. I don't share the view about the FTC that's being asserted, but even if, just assume arguendo that your position is right, taking all of the antitrust authority away from the FTC just because you don't like what the current chair is doing, I don't think is the right solution, because it's a solution that derails a century worth of work between these two agencies. And yeah, they have their ups and downs. I'm, former Department of Justice, and sometimes it's good, sometimes it's not. But that's the kind of change that doesn't address the underlying problem. And with that, I'll yield to the gentlelady from Washington State. And I do want to thank the gentleman for his comments.
Thank you. Just very quickly, I just wanted to build on this. We've only had 4 hearings in the Antitrust Subcommittee this entire session. When I was vice-ranking member of the Antitrust Subcommittee and Representative Cicilline was the chair, we did a massive investigation that was 16 months into big tech. And that is the kind of work I think we need to be doing. The hearing that we had in the Antitrust Subcommittee on meat packers didn't work towards solutions. We discussed undoing food safety standards. We also didn't discuss how removing an enforcer, one of the enforcers of the Patman Act, would lessen consolidation and lower food prices. The FTC is a critical enforcer of the Patman Act, and it is the FTC that completed a supply chain study showing price gouging. And it is the FTC that is bringing RPA cases right now. So taking that authority away from the FTC and saying we're going to give it to the DOJ, I think actually is a huge concern. And, I just wanted to be responsive to the gentleman from New Jersey's concerns about this.
And I yield back.
Gentleman yields back. Question occurs on the amendment from the gentlelady from Washington. All those in favor say aye.
Aye.
Those opposed, no. No. And you pin the chair, the noes have it.
Roll call, please.
Roll call request. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Ms. McClintock? Mr. Tiffany? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz votes no. Mr. Klein votes no. Mr. Armstrong, Mr. Gooden, Mr. Van Drew votes no. Mr. Nels, Mr. Moore, Mr. Kiley votes no. Ms. Hageman, Mr. Moran, Ms. Lee, Mr. Hunt, Mr. Fry, Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren, Ms. Jackson Lee, Mr. Cohen, Mr. Johnson. Mr. Johnson votes aye. Mr. Schiff, Mr. Swalwell, Mr. Liu, Ms. Jayapal votes aye. Mr. Correa, Ms. Scanlon, Mr. Neguse, Ms. McBath, Ms. Dean votes aye. Ms. Escobar, Ms. Ross votes aye. Ms. Bush, Mr. Ivy votes aye. Ms. Ballant, Mr. Gates votes yes.
Clerk will report.
Mr. Chairman, there are 7 ayes and 8 noes.
The amendment is not adopted. Who seeks recognition? Gentleman from Wisconsin is recognized.
Thank you, Mr. Chair. I mean, one of the things that I think we've touched on, but I just wanted to lay out the path, because you don't really have to look any further than the 2 antitrust agencies, right? So if you, right now, it almost appears that it's a flip of the coin as to where some of these complaints go, right? So if you file a complaint against a merging party, it's often decided in an arbitrary manner. So if you land on one side of the coin, DOJ, you get to try your case in front of an independent Article III judge, right? But if you draw the short straw, then it's the FTC. And it's not my opinion, I guess, on that. It's more about kind of the numbers. Because you'll then have to try your case in front of the administrative tribunal, and they always side with the agency. Court records from recent case, Axiom Enterprise versus the FTC, reveal that over the past 25 years, the FTC has not lost a single case that went through their own administrative process. And compare that with the agency's scorecard in the success rate, I guess you'd say, in federal court, which is closer to 50%. So, you know, even if they did lose, they could simply vote to overturn that as well, right? So, you know, what is supposed to be a streamlined process for the FTC to challenge a merger has kind of turned into this long, drawn-out, time-consuming process that always leads back to the Article III court. So there's no good reason for, kind of a different procedural standard simply because you drew the short straw. And that's what I think that Mr. Klein is trying to work towards is, it doesn't matter really how you feel about Lena Khan. It's more about the process right now. Seems to be kind of arbitrary at the beginning and then slanted at the end. And I think that this bill would help to fix that. So I yield back.
Gentleman yields back. The question, we're at final passage. Yeah. The question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. Oh, you wanted to? Oh, I thought you were giving me the okay to go ahead. We will back up, and the gentleman from Maryland is recognized. I'm sorry.
I apologize. I'll be very brief because I don't want to get between people and their lunch, but one in particular is leaning on me about it. But to the gentleman's most recent comments, let me just say this. I shared the concern. We had a hearing a couple weeks ago where the people came in, they were professors who talked about the absence of due process with respect to regulatory agencies. And I came in with one mindset, but I left with a different one. And I said to the panel, look, if there are particular due process rights that you think should be added to these regulatory administrative hearings, tell me what they are, give me a summary of those, and I might go with you on those. And I haven't heard back from them on that. But with respect to the point you just made, I don't disagree necessarily that there should be more due process rights in the administrative process. In fact, based on what I heard, I think we need to expand them. But with respect to this particular bill, please keep in mind that just shifting the antitrust authority from the FTC to the Department of Justice has no impact on any of the administrative rights that are in place in all of the other agencies across the board. And in fact, I don't even know if it would completely have, because it's not really outlined here what would happen with respect to the administrative hearings for the FTC. This bill doesn't really lay out what happens to that, but it just moves the antitrust component. So I don't know that it would actually impact the issues that you've raised, which I think are legitimate issues. But for those reasons and more, the big question is, we're not really sure what this bill would do or what the full impact would be, because we haven't had the impact, the hearings on it to judge the impact. We haven't had the GAO report about what the impact would be and how to address those. We haven't had testimony from people here who've run those agencies and departments and could give us their views about it. We haven't had testimony or even correspondence with respect to the current people who are running those departments and agencies. Even if we don't agree with what they're going to say, and I know it's the Biden administration, you might disagree with their positions, shouldn't we at least hear from them before we take a giant step like this and impact one of the biggest legal structures that we have in the United States and the overall economic impact for it? I mean, the biggest players in the world right now, from an economic standpoint, are companies like Google. They're in the middle of litigation on antitrust. They're with the Department of Justice, and I understand under this bill those would go forward. But we know there's going to be more litigation, and we haven't even touched on AI and how things are going to transform over time with respect to potential antitrust issues. Shouldn't we look at that stuff before we, engage in a wholesale move of antitrust authority away from the FTC to the Department of Justice? Shouldn't we have some experts come in and testify about it? Shouldn't we get some work done, whether it's reports from the GAO or wherever you want it? Get it from the Enterprise Institute or, AEI or Hudson. But let's look at it first before we take a step like this. And I'm open to hearing from both sides, but let's do our homework. I think we owe it to the American people to do our homework on these things before we use the awesome authority that we've been given here as members of the House of Representatives, members of the Judiciary Committee. let's use it the right way. Let's do it in an informed way that's based on evidence. Let's do it in a way that's based on data. Let's do it in a way that's based on expert testimony and guidance so that we have assurance. We don't have crystal balls, but we should have the best possible assurance that the big step we're going to take is going to be in the best interest of the American
Would the
people.
gentleman yield?
I'll yield to the gentleman from Georgia.
Thank you. I think the gentleman from Maryland has hit the nail on the head. There being no evidence in support of making this drastic change, no factual basis laid for it, no hearings. Why are we passing the so-called One Agency Act, which I would want to rename the Let's on the Sly, get rid of the FTC Act? Why are we pursuing this? It's because we want to get rid of the FTC. Why do we want to get rid of the FTC? Because FTC has been hitting them in the pocketbook on behalf of consumers, on behalf of the regular working people of this country. They don't like that. I've heard them talk about Linda Khan now twice. They've mentioned her name twice. Say her name, Linda Khan. They want to get rid of her. This bill will help fix the Linda Khan problem. So I urge my colleagues to vote against this bill, and with that, I yield back to the gentleman from Maryland.
Thank you, and Mr. Chairman, I appreciate your indulgence, and I yield back.
No problem. The question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. And pinned the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. Reporting quorum being present, the question is now on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. Pinned the chair, the ayes have it, but recorded vote is asked for. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Gates? Mr. Gates votes no. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes aye. Mr. Nels? Mr. Moore? Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Nagoose? Ms. McBath? Ms. Dean? Ms. Dean votes no. Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy?
No.
Mr. Ivy votes no. Ms. Ballant?
Is there food back there?
Ms. Jayapal votes no.
We gotta wait a while, don't we, guys?
Ms. Hageman? Ms. Hageman votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Bishop votes yes. Ms. Lee, you're not recorded. Ms. Lee votes aye. Mr. Fry, you're not recorded. Mr. Fry votes aye. 14-7. Mr. Isa, you're not recorded. Mr. Isa votes yes. Mr. McClintock? Mr. McClintock votes aye.
Clerk will report.
Mr. Chairman, there are 16 ayes and 7 noes.
The amendment in the nature of a substitute. The ayes have it, and the bill is ordered to be reported favorably to the House. The members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes, and we are adjourned.